Good morning, friends. Namaskar, Sat Sri Akal and Adab. This is my 196th video. Again, it will be covering the most vital and important court case of ADERJI GHASWALA versus Secretary of State India 1911. This bungalow number 9 Arsenal Road at the time of the suit, but earlier this bungalow number was called 23 Staff Lines, situated within the limits of Poona Cantonment. So we all guys need to wake up. On very first question, when was the bungalow numbers changed and when was survey numbers given? So this entire case was fought on these regulations I will specifically name for all of you in 1908. They referred to Bombay Regulation I of 1819, Section 7, His Highness of 1826, Section 21, repealed by 1 of 1827, which did not come in force till 1st September 1827. The two regulations cited were in force before the cantonment limits in questions were fixed in 1827. Then came Regulation 22 of 1827, Section 21. Bombay Act III of 1867, Section 2, 7 and 9 was discussed. The Atchison Cantonment Code 1836, Article 222 was discussed. Jameson's Cantonment Code 1850, Rule 12, 129, 139, 145 was discussed. The Cantonment and Quarters Regulation 1856, Rule 14, 22, 31 was discussed. The Indian Act 13 of 1889, Section 26 was discussed. Cantonment Code 1899, Rule 76, 89 and 268 was discussed. Now, which all shows there was no presumption in favor of the respondent as alleged by him by these regulations or legislatures. So how many people in Pune or let's say anywhere in the southern or the Bombay presidencies have these books which I just mentioned? Now, first and foremost important, the Pune residents must dig into this record in the judicial record rooms of Pune. So this case actually had gone to the High Court on 12th February 1908 and a redirecting of the hearing was done by the court and was sent back to the appellate authority. So the first appeal was discussed by the district judge of Pune on 22nd October 1904. Why? As the two-bench judgment of Justice Russell and Justice Batty, who had heard this and announced a judgment on 29th July 1907, they differed in their opinions. The former favored the respondent and proved the limited character of appellant's occupation. Justice Batty holding that the respondents had failed to establish their titles on the suit property. So that is why this judgment, since it was not a complete judgment, so it was left to the acumen of the High Court and then the High Court again sent it back and finally this judgment came up for hearing. The High Court on 12th February 1900 called for a rehearing which was directed on July 4th, 1908. On order in council granted by Mr. GASWALA's leave to appeal therefrom, the said order being treated as if it had been a final degree on merits and the effect of judgment of 29 July 1907 being treated as neutral, each party being considered as having one judgment in favor and liberty being reserved to parties on the hearing of this appeal to raise such questions of law as they were advised. meaning hereby High Court allowed both the parties for a repleading and evidence. On these documents, which can be traced further on in this Mr. GASWALA case, he finally lost. So we need to understand what were the pleadings of Mr. GASWALA which made him lose. Again, they held full and proprietary rights therein. So he's claiming himself to be the owner. He alleged that they, the defendants, and their predecessors in title had been in adverse possession for more than 60 years. So the norm at that time for adverse possession was 60 years. The suit is time barred. Now, how does the court interpret all this? Now, I'll discuss these regulations and the Atchison and Jepson Code and one by one. What does Regulation 1819 Section 4 say? On receipt of this regulation, the limits of cantonment, including the military bazaar attached thereto, at which any division or corps of army or any considerable detachment not being less than half a battalion may be quartered shall be fixed by the commanding officer. In concert with whom? The cantonment magistrate, the Zilla magistrate or the DC, and then the limits of the cantonments had to be finalized. So this order speaks. Actually, this order is reprinted as Bombay Journal Order dated 15th April 1819. So this Bombay regulation is reprinted. Now Regulation 3 of 1826, Section 21. Now it had some sub-clauses. It says exclusion of private lands at military stations situated within the territories subordinate to the Presidency of Bombay, the limits of cantonments and bazaar, when directed by the Governor General in Council, be marked by a local magistrate and commanding officer in conjunction, subject to the approval of Governor in Council. The limits will not include private property. 2. The plan. The above mentioned limits shall be drawn on a plan approved by the Governor in Council. When they have been approved, will be kept by the magistrate, and another plan would be kept by the Commander-in-Chief. Now, once again, the report which is calling Regulation 3 of 1826 is actually Bombay Journal Order number 496 dated 27th August 1844. Jepson Code 1850, page 132, Article 124. So Bombay Regulation 12 of 1827, Section 21 has similar terms. Again, the Atchison Cantonment Code 1836, Article 22, it provides it is to be understood permission to occupy grounds within the limits of cantonment does not confer proprietary rights on occupant. So 1819 or 1826, when the limits of Poona Cantonment were made, anybody falling or asking for a permission to take a property within it does not. And where is this order now again written? A Bombay Journal Order dated 22nd August 1835 by Jepson Code Cantonment 1850, Rule 12. Permission to occupy grants in military cantonments confer no proprietary rights on an occupant. It continues to be a property of the state and resumable at the pleasure of the government. But in all practical cases, 1 month notice of resumption will be given, and the value of the building may have been erected thereon is to be estimated and paid on to the owner. Rule 139 is the same rule as 12. Actually again printed on 7th May 1839 in the Bombay General Orders. Now Rule 145 again speaks of the same. Owner of the house within the cantonment not being a resident or a military officer are required to have their names registered in the Major of Brigade or Station Staff Officer. Their value of the building has also to be assessed and valued there. A monthly rent which they might ask for the property is even to be told by the owner. So everything is in record. Now this which they call is actually Rule 145 is General Order number 569 dated 8th November 1849. Now the Bombay Cantonment and Quarters Regulation 1856, Rule 14 is absolutely same what we discussed above, but here it again does not speak of what it adds on. Apart from being paid, allotments of ground cannot therefore be sold to anyone. Now here he adds a restriction in this Rule 14 of 1856. Now where is this rule printed? This is the extra line printed here. It is again printed in the Bombay Journal Orders of 7th May 1838. Now Rule 22, houses in cantonments may be sold or let by house owners to officers or others without restriction beyond the permission of local commanding officer. This is Bombay Governor General Order number 677 dated 15th December 1859. Now Rule 31, owners of house within the cantonment not being residents, military officers are required to have their names registered in the major or brigade station. Everything goes on same, and sufficient permission from brigade is given on records or not. Everything is to be done. This is as per the above order which I just mentioned, and this order which is Rule 31 is not available in the last Cantonment Code of 1856. Now the last and the foremost what has been discussed in this case is the Cantonment Code 1899. What does section 76 say? It is the complete section speaks of cesspools, receptacles and filth. So it is basically concerned with sanitation. I don't want to get into the nitty-gritties of this connect. What does section 89 reads? Notice to new building. Now whether this Poona GHASWALA's case, because he purchased the property, so section 89 could not have been issued to him because he was not making a new building. But again this is being discussed there. I don't know why the other counsel who really fought this case very well could not bring up the section 89 does not apply on to him. Because it was not a new building. It was already an existing building which he had purchased. So this section also goes away. Now coming to the most important and vital section is 268. Register of private lands. Friends, if this document is brought out, I bet not a single bungalow owner in these cantonments, 57, will be resumed. So please lay your hands on this case. This speaks that the cantonment magistrate shall maintain a register showing regards to all lands which is private property and the building situated thereon. The following particulars have to be ascertained: the name of the cantonment, the number, date of any order declaring the cantonments and defining the limits. Now in the earlier rules, Atchison's and Jepson's code, he's already said by 1819 and 1826 order, the limits of Bombay Poona cantonments were done. So what does it say? The date of registry of site, number of the site as shown on general plan, dimensions of site, boundaries of site, name and description of owner at the date of registry, name of description of owner or agent at the date, particulars of owners, any acknowledgement to be taken by him or not for any proof, the estimated value of the site at the date of registry, any changes occurring. What is left? Poona cantonment, some bungalow owners have been, in the earlier days have been asking for me the Mehta committee report. I can share it, my video would be coming on it. But these reports are not in our favor. The record of right also which was made for Ambala Cantonment, in my coming videos I will be talking, does not speak of it. Friends, this GASWALA is producing exhibit 79. Exhibit number 71. It is a sale deed by Mrs. Betts on 27th August 1864 in favor of Dorabji Pestunji, a government contractor who was the owner of this Poona Cantonment. She hands over every claim right along with title, outhouses, premises marked as bungalow number 23 staff lines. Now here the word in this sale deed is sanctioned by the Brigade General Commanding Officer Poona on 27th August 1864. So the entire case apart from that leads to this word sanctioned. Some bungalow owner just shared a document, a word grant was written in his sale deed. I know people don't want to believe into me right now. I have read more than 1,000 more registries, starting the oldest registry of Ambala 1832, and then Ahmednagar 1855, Colonel Jalnawala. What are we guys doing? So this word sanctioned therein implies that the occupation of the defendant and the predecessors in title was a permissive occupation. He is not in a position to rebut prima facie the word sanction as exhibited in 71 in 1864 clearly settles the dispute that this property fell within the military boundary pillar. So just imagine this word sanction was put against Mr. GASWALA, and this authority of the feeling NOC or permission took away his case. Just tell me ordinarily every bungalow owner, if you have a property other than cantonment, let's say in any government, DDA, Hudda, Pudda, or your maybe Pune authorities or Bombay, So if we are asking for a sanction of a building plan by the local municipal authority, does that mean that this is a property within the terrain of the army or something? Or is it a grant, old grant? So plaintiff has adduced no evidence whatsoever on remand to show that the word sanctioned was in general acceptance understood to amount to an admission that cantonment conditions applied. The only evidence put forth was Exhibit 382, being the General Order of Commander-in-Chief, 8th July 1856, containing this. The judge wanted my GHASWALA to prove and lead evidence. Application of sanction could only be made for the purpose of that rule and in reference to land held on cantonment tenures. If the practice of obtaining sanction is transfer in cantonment limit was known to be the common practice, it is quite conceivable that such practice might be followed either in ignorance of its origin or ex major catula by person who had no intention of admitting thereby the title of government of the land transfer. And what plaintiff had to prove was that everybody who followed the practice knew that he was thereby making such admissions. The plaintiff has made no attempt to prove this. The judgment concluded, then it has been suggested that as the old regulations directed that no private property should be included in cantonment, it should be presumed that the land in question was not private property. On the maxima of omnia per suminatur, right esse acta, but the maxima applies only to the manner of performance, and the presumption it allows is that acts and duties proved to have been done were done with due formality. When you dig into this maxima and the subsidiaries of this maxima in judgments of 1819, there is a post limine doing also. If I was an old grant prior to the making of the cantonment, who was actually fixing the documentation, the rules to bring me under the terrain of the military authority? It was the defendants. What are the judges relying on? The word is sanction to the Governor General Order 1819, but where has the DC Poona given his acquisition plan? The settlement report. Just because the Battle of Kirki, Poona was lost way back in 1817 when the Peshwas were defeated, the Governor General Order of 1773 restricted the British Army or the East India Companies to annex any territory by war. When they are restricted, then how does Poona fall within it? So many things are missing in this case. I can understand in 1911 how much could you photocopy, how much could you even be educated. I remember my father telling me in 1911-12, or he was born in 1922, there were not even 5 or 8 people educated in Ambala cantonment. So grants where the Governor General orders is to be looked in. The final order was, their lordships are of the opinion that the appellants are mere licensee and that the land in question has been lawfully resumed by the government. You know, you sometimes feel very bad when such beautifully fought cases with exhibits in place are not run. So please, Poona people, find this judgment, dig into the entire exhibit. It's a bundle of about more than 290-80 exhibits, including the statements of various officers. And I bet this case, if we mention in our court case, is easily countered. So I would request Poona bungalow owners to once again wake up. I miss Mr. Bhojwani. He's no more. And since then, I have not been able to either visit or even be very closely associated to the association the way I was then. So please, guys, wake up. Thank you. Good day.